So today, the Supreme Court of the United States issued a landmark Second Amendment opinion in NYSRPA versus Bruen. So today, the Supreme Court of the United States held that the Second and 14th Amendment protects the right to carry firearms in public. Ultimately, the court held that New York's proper cause requirement violates the 14th Amendment in that it prevents law-abiding citizens with ordinary self-defense needs from exercising the right to keep and bear arms. The ruling specifically challenged the law in New York, but will also apply to the 8 other states that still maintain may-issue gun permitting laws, such as California, Connecticut, Delaware, Hawaii, Maryland, Massachusetts, New Jersey, and Rhode Island. Now, in 2008, the Supreme Court recognized for the first time the right to keep and bear arms as an individual right in the Heller case. 2 years afterwards, in McDonald versus City of Chicago, the Supreme Court ruled that this right applies to the states and not just Congress. Now, the Bruen litigation in this case challenged concealed carry restrictions under a statute in New York that required a showing of proper cause for the issuance of a carry permit. Lower courts upheld this New York law, but there were ample constitutional concerns over its vague standards, such as showing that you are, quote, of good moral character before you can get a carry permit. New York wanted to exercise discretion in deciding who they want to have carry guns, be able to carry guns in public. But gun owners rightfully challenged that, arguing that the law flips the constitutional presumption onto gun owners rather than the government. So in Bruen, the 6-3 majority opinion, authored by Justice Clarence Thomas, joined by Justices Alito, Gorsuch, Kavanaugh, Barrett, and Chief Justice Roberts, rejected the two-step approach often employed by the lower courts since the McDonald case, saying that the Constitution demands a test rooted in the Second Amendment's text, as informed by history. The court expressly held that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. Quoting the McDonald opinion, the court held that the constitutional right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. The court said, "We know of no other constitutional right that an individual may exercise only after demonstrating to the government some special need. That's not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It's not how the Sixth Amendment works when it comes to a defendant being able to confront the witnesses against him. It's not how the Second Amendment works either when it comes to being able to publicly carry a gun for self-defense." So what does all of this mean? Prior to today, the Supreme Court had only established a right to have a handgun in one's home under the Second Amendment. That's all we had, as recognized by the Supreme Court. Now, as was hoped for and as was widely expected, the court has now recognized that the right to, quote, bear arms includes, obviously, the right to do so outside your home. States such as New York obviously still have numerous gun laws in place which restrict and affect this right. So going forward, Justice Thomas's opinion means that courts should uphold gun restrictions only if there is a tradition of such regulation in U.S. history. Justice Thomas correctly notes in his opinion that in 1791 there was no broad prohibition on the public carry of firearms, with their exclusion only being limited to certain, quote, sensitive places. Some of the more low-information politicians and commentators out there today, you'll hear them argue that only muskets were available in 1791 and that therefore we should now be limited to muskets. Setting aside the obvious flaws in their logic, which would likewise render the First Amendment inapplicable to modern forms of communication and technology, the story of America is itself interwoven with the invention of, the use of, and the perfection of the American long rifle, which is by its very definition not a musket, and which was used respectively in war, in acts of self-defense, and for other uses such as recreation and hunting. One could also point out that in 1791, cannons were indeed available in 1791, including ships full of them, lawfully available for private ownership and operation. But those are just facts. In response to this opinion in Bruen, New York Governor Kathy Hochul expressed that she believed this opinion to be, quote, absolutely shocking that they have taken away our right to have reasonable restrictions. We can see where this is headed in blue states such as New York. What happens when state and local governments refuse to enforce federal constitutional law, such as the Bruen decision, as it is now? The remedy available to us citizens is to sue under 42 U.S.C. Section 1983, i.e., a federal civil rights lawsuit. But not so fast, and this is where qualified immunity comes in. There's usually a lag period between a change in the law and the time in which the federal courts will hold government officials, such as police officers, liable for monetary damages under Section 1983 for committing civil rights violations. The excuse generally is that police officers can't be expected to know of every change in the law as it occurs and should be given what is essentially a grace period before being held liable for violating that law. Will that happen here? Will that happen here if lawsuits are necessary, which I guarantee they will be for many years to come at this point? And if so, if those lawsuits are necessary, how long will that grace period last according to the federal courts? We'll just have to see. But it doesn't help that federal law enforcement is already announcing their, quote, respectful disagreement with this opinion. The U.S. Department of Justice issued a press release today saying, we respectfully disagree with the court's conclusion that the Second Amendment forbids New York's reasonable requirement that individuals seeking to carry blah, 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 blah. So here you have a branch of the executive branch respectfully disagreeing with the Supreme Court of the United States. So, wait, how does separation of powers work again? Which article or amendment in the Constitution creates and governs the Department of Justice? Which amendment is that? Because the Supreme Court, I know that is under Article 3 of the Constitution. I'm trying to figure out where in that document a branch of the executive branch can disagree with the, quote, conclusion of another branch. I mean, that is, I guess, for another case. But we can see where this is going. You know, legitimacy is really the currency of the courts, and we've seen what some left-wing groups do or government officials do when they disagree with judicial decisions. They attack the legitimacy, and they basically commit what really is an insurrection, or an attempted insurrection. But qualified immunity will not be a defense to cities and county governments who adopt policies and practices that violate federal constitutional rights, now including the Second Amendment as defined by Bruen. So instead of suing individual police officers, counties and cities can be sued if they maintain a policy of violating federally protected rights, which Bruen is now. Cities and counties cannot assert qualified immunity like an individual police officer can. Now, on the other hand, states don't need to assert qualified immunity because they are not liable for money damages in the federal courts as per the 11th Amendment. So I look forward to going into this decision in a little more depth. It just came out today, but that's the gist of it from my understanding. I've posted the full opinion up on the website at thecivilrightslawyer.com, so please check it out. It's an absolutely awesome read, and it's going to change a lot of litigation from here on. It's going to streamline Second Amendment challenges, and I believe it's a fantastic opinion, and I really look forward to seeing where it goes from here.